Welcome everyone to the 2020 Holy Cross Lawyers Association Fall Homecoming event, Perspectives on Practicing in the Age of COVID-19. I'm Maura Sweeney, Director of Alumni Career Development at Holy Cross, and I'm happy to welcome you to today's session for our first virtual homecoming celebration. I'm joined today by our featured speaker, the Honorable Christopher Droney from the class of 1976, as well as the chair of the HCLA, John Loughnane, from the class of 1987. We'll be together for an hour today, and for the first portion of our time, Chris and John will guide a discussion on the challenges of practicing law in the age of COVID-19. This is a meeting, and so we encourage you to turn off your camera and mute your microphone during the formal presentation. There will be opportunities for questions, and certainly you can submit those in the chat, and we'll keep an eye on that. It'll be a nice way to have an active conversation during the formal presentation. There will be opportunity for networking in some breakout rooms at about the 40-minute mark once the formal presentation is over. We encourage you to introduce yourself in the chat. This is not our typical way of getting together and networking, but it's still a wonderful way to connect from wherever you are. So if you introduce yourself with your name, class year, and where you're connecting from, we can begin to make some connections even before the networking portion. This presentation is recorded for that first half. I'll stop the recording once we get to the breakout sessions. And we'll share it with all participants so that you can listen in again later. With that, now it's my pleasure to introduce you to the chair of the HCLA, John Loughnane, from the class of 1987. And John will do the honor of introducing today's featured speaker. Thank you.
Thank you very much, Mara. Although I regret we cannot be on the Hill today, I am very thankful for all of your efforts in bringing us together virtually. It is my great pleasure to join fellow Holy Cross grads today in discussing perspectives on practicing law in the age of COVID-19. I'm particularly pleased to have the honor to introduce our featured speaker, the Honorable Christopher Droney, class of 76, who's now a partner at Pitney. Before proceeding with further introductions of the judge, I wanted to just take a moment to acknowledge the passing of two particularly impressive folks in the law this past week, unfortunately. First, Chief Justice Ralph Gantz, the Chief Justice of the Massachusetts Supreme Judicial Court, which is the top court in Massachusetts, passed away earlier in the week. With respect to him, many organizations have put out statements acknowledging his contributions to the law. I wanted to just mention briefly a statement that I saw, or some remarks put out by Christopher O'Hara, class of 83. Chris noted that Chief Justice Gantz was a superb Chief Justice with a brilliant legal mind. As important, he was a compassionate and a decent person and a champion of justice and equality for all. He was widely admired by a legal community and will be sorely missed on a personal and professional level. I thought that was particularly well stated by Chris, and I wanted to share that. And also, of course, the news from last night with respect to Associate Justice Ginsburg from the United States Supreme Court. Many statements similarly issued in the brief hours since her passing last night. I recommend reading about her life as much as you possibly can. Chief Justice Roberts put out a statement saying, "Our nation has lost a jurist of historic stature. We at the Supreme Court have lost a cherished colleague. Today we mourn, but with confidence that future generations will remember Ruth Bader Ginsburg as we knew her, a tireless and resolute champion of justice." So I know our guest, Judge Droney, has interacted with Judge Ginsburg personally. So let me introduce him just a little further. He might have some remarks before he gets into into the discussion about the COVID impact on practicing. So Chris graduated from the class of 76 at Holy Cross, followed by UConn Law. He was in private civil practice in Hartford, focused on civil and criminal trial work. He was appointed to serve as U.S. Attorney for Connecticut. Thereafter, for 14 years, he served as a federal judge for the United States District Court for the District of Connecticut. He followed that with service for 8 years in the United States Court of Appeals for the Second Circuit. Earlier this year, he joined Pitney as a partner in a litigation group and as a member of his appellate practice group. This is very brief summary of Chris's impressive career. I highly encourage you to read his full bio on the Dave Pitney website or on the invitation to this event. Suffice it to say that Chris has developed a wealth of knowledge and experience in the course of his impressive career. On behalf of the Holy Cross Lawyers Association board and membership, we extend a warm welcome to you, Chris, for joining us today. Thank you.
Thanks, John, and thanks, John Moore, for setting this up. It's my privilege to be with you this morning. And I did just want to say a word about Justice Ginsburg. She was the Circuit Justice for the Second Circuit for the whole time, the 8 years I was on the Court of Appeals, and I saw her frequently, a few times a year, and talked to her privately a couple of times, and she was a great person and just a great justice. We're going to miss her a lot. So I know our thoughts go out to her family as they go through this. So, John, you want me to jump right in and talk about the crisis?
Yes, please do. As Mara said, if folks have questions, they can certainly submit them, and we encourage people to feel free to use the chat function, which we'll be trying to monitor as well. Yes, Chris, go ahead.
So all of we lawyers have been particularly affected by the COVID-19 crisis, whether you're a judge, whether you're in private practice, public interest law, you're an academic, whether you do litigation, whether you do deals, whatever you do, our lives have changed so much in the last 8 months or so. What we used to do in person, like meetings, depositions, closings, trials, just don't happen anymore. So we've had to come to grips with that and adapt to it, which I think we've done well. This crisis will be over, we hope shortly. But one of the things we wanted to talk about at the end is just what are the long-term effects of this. I think it's safe to say the practice of law, no matter what you do, is going to be changed greatly through this period and will last forever. So we wanted to talk about what people think the long-term effect will be. And what I thought I'd do is talk this morning with John about what I've observed and the changes to state and federal courts in particular, with a focus on litigation, both appellate and trial litigation, and discuss some of the things that I've learned through my observations and talking with others and reading a lot of articles about it. First, I wanted to talk, John, if it's okay with you, about the use of technology during this time for remote proceedings. We all use it every day, whether it's Zooms, Teams, WebEx. We have virtual file systems now, so we don't have paper anymore. We don't send letters anymore. And there are no more bar meetings in person or seminars. And probably the hardest thing is no more dropping into each other's office just to kind of run something by John or some other experienced lawyers to get some advice.
So Judge, the use of technology is pervasive. There's no question. None of us could get through our day now without the use of technology in the practice of law. But do you have any particular tips or suggestions as to how that technology can be used effectively and efficiently to advance the interests of the law?
I do have some tips. Most of them learned through mistakes I've made, as we all do as lawyers. That's how we learn. But the first tip is just, I have to understand completely this remote technology. You've just got to jump in and figure it out for yourself. And I use mostly Zoom for my remote meetings, but I've used WebEx, Skype, Microsoft Teams. You've got to know how to share documents. You've got to know how to use breakout rooms. You have to know how to initiate your own meetings. You've got to know how to use PowerPoint in sharing documents, because you're at such a disadvantage if you're not really familiar with all. I think most of the younger lawyers are familiar with it, but some of us older lawyers have had to really learn how to do this, but there's no choice. And it goes with word processing too. You have to know how to write your brief and do your research on 2 screens. You have to know how to edit documents of others and get them back quickly. And then there's some appearance issues I wanted to mention too, John, on how you appear on these. So anyways, so what I've learned is that your business casual, yeah.
Chris, I was just going to say before you move on, just quickly, one important thing that people absolutely need to know is how to redact a document, right? So the use of technology in the law is pervasive. We've seen instances in the past few years where people have submitted filings to the court thinking they had redacted the document when in fact they had not properly done so. And that can be a major source of embarrassment or breach of a duty, I think, to a client not to protect confidentiality. So, you know, the use of technology, whether it's Zoom or it's knowing how to redact a document, or it's a professional obligation at this point. So, yeah, please tell us what you've learned about making an appearance.
So just about this issue of redaction, though, John, I've seen, I'm sure you have and others too, that when people are screen sharing, a lot of times somehow the document other than they wanted to share, the slide from the PowerPoint doesn't show up, but you see the lawyer's schedule, you see the lawyer's emails, and you see other documents too. So you've got to be very careful about that screen sharing. So about the appearance, you know, it's common sense of how you appear. Make sure that your lighting's correct, your camera is at eye level so people can hear you and see you well. Make sure your bandwidth is strong enough to participate well. Make sure your teenager upstairs is not using the internet at the same time you're on a Zoom meeting to you know, do some kind of game with his friends. And make sure other phones in the room are off. And on the issue of appearance, we've all heard these horror stories. I know, you know, that they're going around now, but I saw one. So that about 3 weeks ago, I was in a trade association Zoom meeting with 50 lawyers from around the country, and we were all supposed to disable our camera, which we all did except for one lawyer from Boston, sorry, Boston, who, so we had the 4 presenters and this lawyer was still on it, even though they were sending messages, you know, turn off your camera. And it was one of those hot days that we had this summer, and he started off in it looked like he just got out of bed and he had a Bruins t-shirt on, but I didn't know everybody was watching him. But then it got worse, and it got really hot, and he took his shirt off. So I actually saw that. So, you know, you hear these anecdotal stories, but they really do happen. So be very careful about.
Was there an instruction given for people to ignore what they had seen, or was that abided by?
No, it was mostly chats, private chats of "Do you believe this?" kind of thing. So that was all we had. The other tip I'll give, heard from others, and I do it myself, is, you know, have a dedicated area in your home where you do your work and your meetings every day. People have said the best thing to do is have a set schedule too, so that you're always going online at 8:30 or whenever, and that at the end of the day, you make sure you've got your schedule for the next day set. They say that's the best way to keep organized, because there's so many distractions for all of us, you know, taking the dog out or playing with your kids or going for a walk, which is all good things to do in moderation. But at least the things I've read said the schedule is a good idea.
So it's critical to know where the mute button is. It's critical to know how to stop your video. It's critical to know how to make an appearance in a way that maintains your professional integrity. What about how COVID has affected court proceedings, specifically from your perspective, at both the appellate and the trial court levels?
Sure. So why don't we start with appellate arguments? And this is the area with, as far as I've observed, the fewest and the smallest changes. And it seemed to have settled into similar procedures for both state and federal courts. But there are some differences from court to court. So the best advice I can give is always check the websites for those courts, and always check to see if there's any orders. And that means if you're going to have an argument on Wednesday, make sure you check it again Monday or Tuesday to see if there's any new orders. And that does happen, where you're surprised by some changes right away. And I don't think there's many differences for if it's a video argument for the appellate court. It may be a little structured, a little more structured than in the past, but I've watched a lot of them, and I really think they're proceeding just as they were before. And some of the appellate courts, like the Connecticut state appellate courts, are now in person too, so that they're remote, you know, they're distanced, but they're in person, so they're returning to that. I would say the biggest change is like in the Second Circuit when it's audio only, and there's a couple other circuits that are audio only, and that does make a difference, because not only can you not see the judges, but they can't see each other. So there's none of these visual cues that you used to see when you were in front of a panel, like in the Second Circuit with 3 judges, or the Connecticut Supreme Court with 7 justices, where you could tell a judge wanted to pursue something with you, and you kind of focused your attention on that judge. But they can't see each other either. So the presiding judge, just kind of does it like the Supreme Court did this year, which is go from least senior to the most senior, and it's very structured, and there's fewer interruptions, fewer back and forth discussions among the judges. And I know the Supreme Court has just said that next term they're going to be doing audio only as well. The other change, as well as this year, and the other change is that many of the courts have now had a policy of the first few minutes are uninterrupted by an agreement of the justices or the judges. So make sure you know whether that's going to happen, because you got to be ready to go for the 3 minutes, like in the Second Circuit, without any questions. And it's not 5 minutes and it's not 10 minutes. It makes a big difference.
So, Judge, I know some of these recordings, for example, the Supreme Court has broadcast, live streamed their recordings. Do you think it'd be valuable to listen to the panel that you would be presenting in front of, or otherwise spending time learning about how these hearings work in practice?
Absolutely, John. So most of the courts, the appellate courts now, do have live streaming, so you can listen to an argument while it's going on the week you have an argument. Now the panel may not be the exact same, but usually, like in the Second Circuit, 2 of the 3 judges will be the same, so that's very helpful. And listen to the kind of case that you're having, whether it's a criminal case, a sentencing, or try to pick out those. And then there's archived arguments as well. You can go back and listen to arguments from the week before, or some more distant time in the past. And I think that's great advice, John.
And maybe if I could just ask you, from your experience as both a trial court judge and an appellate judge, how important were the nonverbal components of sitting behind the bench? And do you feel that some of that is obviously, how much is that affecting the decision-making ability of a judge, do you think, at this point, not having that ability to pick up on nonverbal symbols in the court?
Well, I think it's really important to the lawyers. I remember the best nonverbal cue I would get when I was arguing before these courts is, if it looked like you were winning, sit down. So if you weren't getting a lot of questions, don't open up some areas that might cause some disagreement among the judges. So you miss on that. Or a particular judge you're having trouble with on an issue you want to focus on, you can see that a lot better than you can hear it only. So, experienced lawyers like yourself, John, you pick up on that and you adapt to that when you're arguing, but you can't do that now if it's audio only.
Okay, thanks. What about at the trial level? What are you seeing now? So we just covered the appellate level. Let's talk a little bit more about the trial level.
Okay, why don't we start with the civil side and start with non-jury matters. And this is the experience of the last 6 months or so. Some of the emergency non-jury proceedings are being conducted in person, but the vast majority are remote now. Different jurisdictions are using different technologies. I know that Massachusetts is using Zoom, while Connecticut is using Teams. It's in the state court. There are some emergency in-person hearings that are still being conducted, like custody hearings for children, restraining order violations in domestic cases, bond violations, probation violations, where they have, and first appearances often are in person, where you have to make sure the person has a lawyer and size up whether he or she is willing to proceed and able to proceed right away. But the rest are, as you know, are proceeding remotely. These are motions hearings, like motions to dismiss, motions to strike, summary judgment, discovery disputes, and they seem to be proceeding well. The judges and lawyers like them. They're easy to attend because you're doing it in your office. You don't have to wait for the next your proceeding hearing to conclude before you start, so you're not wasting as much time.
Do you think there's a trend or a possibility that some of the successful handling of these routine uncontested, non-contested matters may continue post-pandemic and save parties and the system the cost of doing something physically when it seems like it could be done remotely as well?
Absolutely, especially like a motion to dismiss in the federal court where it's based just on the pleading. So all you have is the complaint and the answer in special defenses before the judge. There's not a lot of documents to look at. And I think we're going to see that forever now. And it's convenient for the judges, and it's convenient for the lawyers, and the clients can participate too. So that's where you start with the long-term change. But once you start getting into more complicated document cases, like even summary judgments, where you've got to direct the court's attention to, page 48 of Exhibit Z, it gets harder. And most of the judges are saying, even in those cases, you have to tell me ahead of time which particular document and what pages you're going to refer to and give me hard copies of it. Because many of the judges are older and they're not as good with screen sharing as we are. But then it gets even more complicated when you have evidentiary hearings. I know that there are some bench trials that are going on, some injunction hearings, and that gets very complicated.
Well, so just tell us more about what you've seen in these contested civil matters where there is disagreement about between the parties. It's not a undisputed or non-disputed matter. What is your perspective on how that's how the courts are handling those matters?
Well, what the courts like you to do is to identify what the disputed document is. Say you've got 10 documents you're going to argue about. 8 of them, we agree that they can be considered by the court. 2, we have a hearsay objection to that document or something like that. And the courts are satisfied if you give them copies of those documents, a short memo about it, so that the judge can review it ahead of time and then rule on it. But as we all know, a lot of times this comes up without any warning. Your opponent brings up a document you didn't think that she was going to raise, and that's when the courts are not real happy, because they're going to have to reconvene. They're going to have to look at these. The other thing that is troubling to me about this, and it's more so in the jury trial context, is as lawyers we know we like to surprise some witnesses with documents. Well, you said the light was green just now, Mr. Jones, but do you remember a prior statement you gave 2 hours after the accident when you said the light was red? And I don't remember saying that statement. Well, let me show you a statement to refresh your recollection. I mean, that's going to be the hard thing to do in all of these cases, I think, when the judges require the documents ahead of time, because that witness will know you're going to cross-examine him about that prior statement.
So, Judge, you've mentioned the difficulties of jury presenting effectively in front of a jury. It seems like there's a host of issues here in terms of jury selection. How do people bring people in for selection? There's a whole host of issues in terms of the jury matters. Do you want to comment on some of those?
Sure. So all the courts that I see, at least in New England, are saying they're going to start civil jury trials this fall, between September and November, all the courts I've seen. But there are particular problems with those. For example, how do you do jury selection during the age of COVID-19? You've got a lot of people who don't want to come in, especially older people, where there's going to be a big crowd. So how do you get a fair cross-section of the public when older people are going to be reluctant, or people, just scared of the virus, and you're probably going to let them not come in because of that. So, and then once they come in, you've got to keep them separate. How do you do voir dire of these prospective jurors, where you ask them questions? In the old days, they'd be sitting next to each other in the jury box in the courtroom. Here, you've got to bring them in separately, I think, and it's going to take a lot more time to do it. Then how do you size up prospective jurors to see whether they're telling the truth about any bias? My son is a corrections officer, but I won't be biased in this criminal case where it was an assault on a police officer. That's the kind of prospective juror we saw all the time. And you want to say, well, you said you're not going to be biased, but it's obvious to think you might be. And you got to look the person in the eyes to see if she's telling the truth or not. So that's going to be very hard. And then during the trial itself, how do you display evidence to them? How do they deliberate remotely? I used to think with all the juries that I had that it was helpful when they were deliberating to be in a small room together where they were really arguing with each other. That's the truth-seeking function. if they're all doing it remotely, it's going to be different. And I'm not sure that those verdicts are as reliable as they were before. And then, you know, how does the judge supervise them during deliberations? We were always worried. I was always worried about them looking at a newspaper, going on the internet to do research on the case. How do you make sure that's not being done? So it's really a challenge, I think, this fall.
So plenty of issues, topics, concerns, and as Mara mentioned earlier, we're going to have a breakout session after these remarks, and hopefully, in addition to networking, there could be some discussion about what folks think about ways to handle this. In the interest of time, Judge, let's move on to talk a little bit more about criminal proceedings and how they're particularly affected, in your view, in the current situation.
Well, let's talk about the criminal jury trials that they're planning to start. I mean, these problems I mentioned in the civil context are even worse, or even more difficult, I should say, in the criminal, because there's constitutional rights at stake, right? So how does the client consult with his or her lawyer during a plea or a sentencing? Well, there's a lot of questions that they have. And, you know, when they were sitting next to each other, they could ask for a recess, or, you know, I got to explain what this count of the indictment means to my client a little better. How about victims? Are they going to be able to come in and observe sentencings, participate in sentencing? They have rights now to make statements during sentencings. Jury selection, the rights are even more difficult to deal with, like jury selection with peremptory challenges, cause challenges. And then in the trial itself, how does the defendant confront his or her accuser, the confrontation clause of the Constitution? You know, it used to be the lawyer was there with his client facing the accusing witness and really roughing up that witness to make sure he or she was telling the truth. How do you do that if the witness is remote or behind plexiglass even, or in another room? The Supreme Court said that's only permitted under the Constitution where it's a child sex case and it's a victim testifying in another location. They've never said it's okay to have somebody in a different room. And then in-court identifications, how is that going to be as reliable as in the past, you know, where the person's right in the courtroom? And the last thing I'd say about this, John, is the right to a public trial. The defendant has a right to a public trial with members of the public, making sure that everything is being done properly. But also we, the public, have a right to observe the trial. And the press does too. So these are very, very difficult questions. And I think this fall is going to be a really challenging time for these court systems to deal with all this.
I'll say, and I think that the list of questions that you just highlighted is really the tip of the iceberg, right? There's so much that people haven't really thought about, but I certainly hope that members of the HCLA will be actively involved in discussing these issues and developing solutions in their local bar associations, with their local courts, on behalf of their clients, and try to figure a way out of the situation. I know you wanted to talk about mediation quickly, Judge. Any thoughts about how mediation is operating in this current environment?
Yeah, I've been doing more of those now in my practice than I had before, although as a district judge, I tried to settle a lot of cases. So, but my experience is that and you do mediations, John, too, so I'd like to hear what you have to say about it too. But my experience was this spring, nobody was doing mediations because they thought this was a short-term problem, and everybody thought mediations are better in person. But now we see it's a long-term problem, so there's a lot of mediations proceeding. And there are a lot of advantages to remote mediations, like you don't have to fly your client in from Oklahoma City to Boston to be there for a settlement conference, right? So there's an advantage to having a Zoom mediation conference. The judges like it more because they don't have everybody shuttling in and out of conference rooms to, oh, let me talk to the plaintiff and her lawyer and, you know, that kind of stuff. But the question is whether there's enough pressure brought to bear in online remote mediations, where that's an important part of settling a case, where I'm a former judge and I say, look, John, I don't think your case is worth $2.4 million. I'm just telling you what I think. You're paying me to tell you what I think, honestly. I think if you can get $1.5 million in this case, you should take it, you know. And if you're doing it in the same conference room and you can look me in the eye and say, well, you know, he seems to know what he's talking about or doesn't. That's helpful. But what do you think?
Yeah, I think there's been decades worth of advancement in how people solve problems. Without the pandemic, and people had thought through how do we use technology creatively to handle mediation, it would have taken 20 years for people to come up with this. So out of necessity has been born this tool. People have been quick to adopt it, using it. I think it's quite possible that there'll be advances in technology that address some of the issues that you mentioned. Nothing's ever going to replace the in-person meeting, but there are certainly efficiencies in the costs. And on a typical business matter, it's quite possible that large-scale remote mediations will continue, perhaps with some, like I said, advancements in the technology that will make it, more efficient than it even is right now. So I'm excited to see what technology might hold down the road for those that want to continue to advance this area. I know we have just a couple of minutes left before we get to the Q&A and the breakout. You wanted to talk about the future a bit, Judge.
Well, I'd like to talk about it with you and the other people who are participating this morning too in our breakout rooms, but just one final thought about it. We've talked about the effect on practicing lawyers with some experience. One of my biggest concerns is newer lawyers and law students. When we were first starting out in practice, we had a lot of tools that helped us become better lawyers, going to seminars, going over to court to watch a closing argument, going to the lawyer next door to say, I've got this discovery dispute, what do you think I should do about it? And meeting other members of the bar, Boston City Bar Association, New York City Bar Association. That really helped all of us to become good lawyers. And I'm worried about that for the newer lawyers to not have that cross-pollination. But also for law students, I get the sense there's fewer jobs out there now because the law firms, our law firms are suffering from being closed for so long. I mean, we're doing our best, but you read every day about a law firm laying off people. So I think that the law student hiring crisis of 2008, which we kind of got over, things were really doing great up until last year, in my view, I think it's returned a bit. So I feel badly for the newer lawyers and how they're going to deal with this.
I think it's a real concern. I would encourage folks, though, to abide by the following 4 words: be optimistic, smiling, active, and perceptive, right? I want folks to understand that there's a real challenge. Things are not going to be done the way they were done in the past. But in this turmoil, there is opportunity to do things a new way. Take advantage of the tools. With respect to the HCLA, for example, if I just put a plug in, we have an active LinkedIn group dedicated to the group. There's more than 1,000 members in there. Use the tools smartly. Go to the HCLA website, which Mara maintains on the college's website. There's various tools, there's directories. I think if you reach out to people in a targeted, thoughtful way, they will be there for you, but you're not going to be able to just sort of go across the city and have a cup of coffee with them, or you're not going to be able to walk down the hall and pick their brain. You're going to have to do it in new ways. Use some of the new tools that are available. But I agree, it's a definite challenge for folks. Boy, that was pretty much right on the money in terms of our timing, Judge. Thank you very much for that. Maybe we'll go back to Mara, unless there's anything else you wanted to say before we do that.
Just thanks to you, John, and to Mara once again for permitting me to be part of this.
Our honor, for sure. Mara, any Q&A? I see some activity in the chat room, but let us know if there's any Q&A that's come in or any particular chats that you wanted to bring to the attention of the group.
Yes, thank you. I noticed that there is one question that came in asking, are court systems anticipating that jury trials will be held with jurors attending from their homes as opposed to jurors going to the courthouse?
So what I've learned is they're working through this now, but as I understand it, they're going to require all the jurors to come into the courthouse, and they're setting up designated areas that keep them separated. They require a lot more room than the old days where you just had a jury deliberating room. But from what I've seen, from all the information I could find, they're still requiring jurors to come, prospective jurors to come into the courthouse.
And that will get interesting when there are jurors who have a real sense of apprehension about going into any public space, and the process of analyzing that and vetting it, I think, is an issue that's going to have to be dealt with. I'm not sure that anybody really has an answer to that right now, but it's going to be a real-time issue that plays out, I believe.
And one other question came in from Stacy. Welcome, Stacy. She asks, do you have any thoughts about effective trial setups for offices when we are doing trials remotely?
Well, I'd have to think about it, I guess. You know, especially if you're going to be viewed by a jury and the judge, make sure your background looks professional. I mean, I wouldn't do it like Tom Ferry did it in his bedroom this morning when I saw him sign on like a little table. I would try to look as professional and as dignified as you possibly could, and be mindful of what the backgrounds look like. And I'm not a fan of the virtual backgrounds. Most people are, but I think that they don't work well at times, and it's hard to rely on them. So I would make sure, whether you're in your office or you're at home, that you look like you're taking this very seriously, and that you've got the two monitors to deal with during the trial, and you know, that you don't have any distractions while you're on trial.
I think that's very good advice. It's amazing some of the stories I've heard of what people have been doing, or the setting they put themselves when they're presenting to a court, and the slightest thing can be distracting. You know, an odd colored drape, or a strangely designed piece of furniture. I mean, people's attention gets very distracted. So, you know, don't risk losing anybody's attention by something in the background that's going to take away from the importance of your arguments and your points. So, Mara, I know we're on a tight schedule, and we should probably put a plug in here for Father Burrows, who is speaking at, is it 11 o'clock?
That's right, at 11 o'clock.
And if folks have not yet registered for that, they certainly can still do so, I presume, on the college's website.
Yes, if you go to the Holy Cross website and click alumni on the top menu, you'll see there's a special spot for all of the homecoming information, and you can find the whole list of today's events, and you can register for Father Burrows' talk at 11.
Great. So unless there's any further Q&A or chat, maybe you would want to break us into a breakout room for the remainder of our time. And I really do appreciate Judge Droney for joining us this morning. Thank you for those remarks, and all the other participants as well. And for those who missed this, it will be recorded and posted by Mara at her convenience.